please remember to leave a like, a comment, share the video about, and if you haven't already, subscribe. Thank you. Well, isn't this just fantastic? Hello everyone, welcome back to another video. Today I want to go through a document that was released onto the Twitters concerning Destiny's Revenge PORN case, because Pixie's attorneys have taken the unusual step of requesting that the court utilize the Hague Convention to subpoena testimony from Destiny's ex-wife Melina. Now, on the face of it, this intrigued me, because unless they intend to use Melina to humiliate Destiny, I wasn't entirely sure how useful Melina could be. But at the same time, as an outsider with no real understanding of the system, I can understand wanting to acquire as much context as possible if your intention is to perhaps tear apart the facade of Destiny by getting first-hand knowledge from somebody who was with Destiny for a time. So the plan for today is to go through all 7 pages, so probably 6, the 7th being some kind of declaration of the document, and see if we can understand any of it. As his case unfolds, my intention was always to maintain some familiarity with it in case it all went wrong for him or didn't. So, Jane Doe, plaintiff, versus Stephen K. Bonnell II, the defendant. Plaintiff Jane Doe's motion for letter of request for international judicial assistance to compel discovery from Melina, I don't know how to pronounce your name, in Sweden, pursuant to the Hague Convention. The plaintiff, Jane Doe, by and through the undersigned counsel, hereby respectfully file this unopposed motion for the issuance of a letter of request to serve a subpoena to testify and produce documents on that person, Melina, a resident of Sweden pursuant to the Hague Convention on the taking of evidence abroad in civil or commercial matters. In support thereof, plaintiff states as follows. The legal standard. A letter of request, also known as a letter rogatory, never heard of that word, do forgive the pronunciation, balls up if it has been ballsed up, is a document issued by one court to a foreign court, requesting that the foreign court, 1. Take evidence from a specific person within the foreign jurisdiction to serve process on an individual or corporation within the foreign jurisdiction, and 2. Return the testimony or proof of service for use in the pending case. I've always been curious about international law when it came to obtaining information. I know typically, from what I've seen, Americans are less than receptive to reciprocating the sharing of information or sending people over. Something to do with the Constitution or something, I don't know. And many countries around the world, though, will bend over backwards to accommodate for the US. That's not a bad thing or a good thing, it's just something I've seen over the years. To page 2. Both issuance and the enforcement of letters rogatory rest entirely upon the comity of courts toward each other. Comity is the recognition which one nation allows within its territory to the acts of another nation, having due regard both to international duty and convenience and to the persons who are under the protection of its laws. When considering traditional notions of comity, the Supreme Court reasoned that the court is responsible to base its comity analysis on 5 factors. When considering a discovery request abroad, this is where it cites something. The 5 factors are as follows. 1. The importance to the litigation of the documents or other information requested. 2. The degree of specificity to the request of the request. 3. Whether the information originates in the United States. 4. The availability of alternative means of securing the information, and 5. The extent to which non-compliance would undermine important interests of the United States, or compliance would undermine important interests of the state where the information is located. In addition, courts apply the discovery principles contained in Federal Rule of Civil Procedure. Parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim and proportional to the need of the case. One of my favorite things about these court papers is they cite a lot of good information to help me understand, and by making it a point within the papers to define, it makes it a more fascinating event. Let's go with that. Relevant factual background, page 3. This action involves the non-consensual disclosure of intimate images under the federal statute commonly known as CARD-II, CARD-II 2, as well as a claim for violation of a statute, it's referenced, yes, for sexual cyber harassment, intentional infliction of emotional distress, and invasion of privacy. More specifically, plaintiff alleges that multiple times Blundell non-consensually disseminated through electronic means a video of plaintiff and him engaging in sexual conduct. The video was later obtained from one of these recipients and uploaded onto the website Kiwi Farms by an individual with the screen name Solo Tiny Leaks, and was then disseminated on multiple other pornographic websites. The video has been viewed more than 78,000 times and was discussed on several platforms. Additionally, videos posted on social media about the video were viewed over 90,000 times. The viral leak made plaintiff feel depressed, humiliated, and that word that I'm not going to say because there's always a risk this one, because its destiny could well get pulled anyway. YouTube is quite sensitive to me covering the subject. Relevant procedural background. On the 18th of February 2025, plaintiff filed her initial complaint against Blundell. On the 19th, the court granted plaintiff's request to proceed under a pseudonym due to the sensitive nature of her allegations. On the 4th of April, the court entered an order setting trial calendar call, reference to magistrate judge, pre-trial deadlines and pre-trial procedures, setting inter alia a discovery cutoff of December 16, 2025 and a trial date of the 18th of May 2026. Well, this is going to drag out, isn't it? On the 2nd of September 2025, the court granted plaintiff's motion for a protective order. On the 5th of September, plaintiff filed with leave of court an amended complaint. I remember when the complaint was amended, there was speculation that perhaps this wouldn't go much further because changes had to be made. But from what I've learnt over the years on YouTube, especially from law tubers, is that it is quite common for complaints to be amended. We saw this with Illuminati as well, repeatedly amended, because that's part of the process. And sometimes you framed your original complaint poorly and there was a hole in it. On to page 4. Argument 1. The need for international discovery. So this may well provide context that we need to understand why Melina has been brought into this. The sought-after discovery from Melina is relevant to the claims in this action, will likely prove highly material to the prosecution of this action, lead to admissible relevant evidence, and is proportional to the needs of the case. Melina is the former spouse of the defendant and is uniquely positioned to provide evidence of the conduct complained of in the AC, as well as similar conduct that she was a witness to. By way of example, Melina is the recipient of certain sexually explicit materials involving the plaintiff. Melina is expected to corroborate plaintiff's allegations, including those allegations regarding Destiny's lack of consent to disclose the video. Moreover, Melina is, or is believed to be, another victim of Destiny's unlawful conduct. Finally, Melina would testify to Destiny's character, as it is relevant to this case. Indeed, Melina is expressly mentioned in the amended complaint as a relevant witness. 2. Alternative means of obtaining the sought-after evidence are unavailable. Moreover, this evidence cannot be obtained by alternative means because Melina's knowledge of facts relevant to this case is unique and central to plaintiff's allegations. However, even if it were available by alternative means for the sake of argument, the mere fact of an alternative method for obtaining the documents is not proof that it is necessarily an effective or efficient method for doing so in this case. 3. And on page 5. The Hague Convention. The US and Sweden are signatories to the Hague Convention on the taking of evidence abroad in civil or commercial matters. 4. Balance of interests among nations. Plaintiff is not aware of any evidence to suggest that the interests of the Swedish government would so outweigh those of the United States governments to bar the issuance of the proposed letter of request in this action. 5. Proposed letter of request. A proposed letter of request in the form recommended by the Hague Conference on Private International Law is attached hereto as Exhibit A. A certified Swedish translation by a translator authorized by that place, as required, will be provided to the court upon approval of this motion. Certificate of Conferral. Pursuant to local rule, undersigned counsel hereby certifies that counsel for plaintiff has conferred with defendant's counsel in a good faith effort to resolve the issues raised in the motion, and that counsel for defendant represent that defendant does not oppose this motion. Mercifully, we knew that Destiny had no objection to this because it was stated on page 1 or 2 anyway. Conclusion. For the foregoing reasons, plaintiff respectfully requests that the court approve, date, sign and seal the proposed letter rogatory to the Central Authority of Sweden to serve a subpoena on Melina to testify and produce documents in accordance with the Hague Convention on the taking of evidence abroad in civil or commercial matters, which is submitted concurrently herewith, and for the clerk to authenticate the court signature by affixing the court seal thereto, and that the letter rogatory. Okay, so it turns out page 6 and 7 is signatures. Yay. Now, as far as the process goes, this is an interesting one. On social media, I had noticed via the Twitters, there was a very divisive attitude towards it. Whether people are desperate, that being the plaintiff, so Pixies, are desperate, they're pulling everything they can to try and find a way to poison the well, perhaps. But then, as mentioned, the speculation that Melina is also a victim and also a part of the problem, to an extent. Others have speculated that because they were trying to get the court order to remove URLs from Kiwi Farms in a civil lawsuit to try and subpoena his wife before discovery while the motion to dismiss is still ongoing. This all looks like a sabotage, or like they're pushing to sabotage. Truthfully, while I find this all highly interesting, my biggest interest is what happens with regards to the NUDES of a 17-year-old girl on his computer. That stuff is still ongoing as well, isn't it? And that stuff is more damaging, and really should lock him up, to be honest. Any excuse, though, to keep that kind of crap on your computer, not acceptable to me, to be honest. Now, as with everything we cover on this channel, I'd love to know what you all think. Please do let me know in the comments down below. I'm going to be streaming here later, but also on Rumble and Twitch. I'm kind of everywhere, yes. If you're interested in joining those streams, I'll link them in the pinned comment. I will also link the tweet where the document is also linked to as well, but I know some people don't like using farms, the Kiwi Farms anyway. I understand it's a darker place, but it does have the link to it, the US court document, and I think sometimes it's always better to look at it for oneself to be able to determine their own perspective on something. If I don't see you online at some other point, do have a lovely day, and thank you so much for listening.